on the matter of Herbit's versus the City of Miami. And council, please state their appearances for the record.
Your Honor, I'm Sam Nubbin for Plaintiff Stephen Herbitz. Mr. Herbitz is here as well as the members of the community as I advise.
Okay, thank you. Good afternoon.
Good afternoon, Your Honor. Forrest Andrews and Robin Jones-Jackson on behalf of the City of Miami.
Okay, good afternoon. All right, so we are here specifically on plaintiff's emergency motion for sanctions against defendant City of Miami for violating court order, etc. So, Mr. Dubbin, you may proceed.
May I use the...
Yes, absolutely. If you need to, you can stay there if you want to refer to your materials, or you can come up here, whatever you decide.
I'll try a little vote.
Yeah, it's not easy. And this lectern is better because it's not closed and confined like that vote, so.
Your Honor, thank you very much for giving us the time on this emergency basis. We attempted to document thoroughly in the motion for sanctions the basis for the relief that's sought here. And so I will summarize it. Hopefully, address any questions you have. But this is a very serious matter involving the City of Miami's pattern of violation of the public records laws in order to conceal from, in this case, Mr. Herbitz as well as members of the public, crucial records concerning its deliberations and decisions over the Flagstone Island Gardens project, which is private development on public land on Mott's Island. This pattern of public records violations goes back to 2013 when the city was negotiating with the related group to double the size of the project operating behind closed doors. Mr. Herbitz sought public records. The city did not respond for almost a month. He sued them, got the records, and when those records were revealed, the related group pulled back because it showed that the city was working behind the scenes with the state and the developer to get approvals that would prevent that expansion from being subject to traffic studies, current environmental studies, and all of the overviews of state agencies with jurisdiction over those particular actions. So the related group withdrew, but the Flagstone group persisted and the city persisted. But in June of 2013, the City of Miami extended Flagstone's permission. Remember, this is a project, to take a step back, it was first approved in 2001. And in 2001, they went through all the proper procedures. Under the charter, there was an RFP, there was a referendum, the referendum was approved, there was a contract that was entered into it, and there was a major use special permit issued in 2004 outlining the development plans. My clients did challenge the zoning decisions at that time, and the courts upheld the zoning. And my client, Mr. Herbitz, went away, and the city and the developer were off to their own devices. But the developer was never able to get that project on track, and the city continued to extend deadlines, revise the agreement in 2006, 2008, 2009, and in 2010 made major changes to the project that we've alleged in the case that's now before Judge Gordo deviated from the RFP that was originally issued and responded to, deviated from the referendum language that was required under the charter to allow that project to be done in the first place, because it's public land and the city charter requires a referendum to approve a lease of public land, and that they had possession of appraisals showing that that land had gone up in value from what would be a fair market rent of $2 million back in 2002 to over $7 million in 2013 and 2014. But the city suppressed that information. That information wouldn't be known to this day if Mr. Herbitz didn't sue the city again in 2014. That's this lawsuit, where the documents were revealed that showed that the appraiser sent an email to the city just before the last vote in May of 2014, that said that fair market value has gone up from $2 million to over $7 million. So what was done in 2013 was, as part of the process to extend and relieve the developer of those obligations, the city extended the deadline to June 2nd. So then the critical deadline was June 2nd, and because this was state land given to the city originally, the state had to approve a modification of the deed restriction because it was supposed to be for only public purposes. And as 2014 was moving forward, the State Department of Environmental Protection was against the project. Why? Because the appraisals were from 2002. The public wasn't getting a fair deal. The state was concerned about the fact that the developer hadn't started the project in over 10 years. And so the state was pushing back, and the developer and the city were facing this June 2nd deadline. Finally, as we document in the motion, the developer was able to get the governor's office to get the Department of Environmental Protection to back off. They put it on the agenda, and that brought about this crucial May 8th, 2014 City Commission vote. And some commissioners, one commissioner was dead set against it. Two felt that it had gone on long enough, but were informed by the city attorney's office that if it wasn't approved at that time, the city would be in breach of a good faith obligation to the developer, and that they had to give the developer at least until June 2nd to meet this deadline. And they said so on the record. So the city approved the proposed modification from the state on May 8th, and on May 13th, the cabinet then approved that. But at the commission meeting, for example, Commissioner Suarez said, look, I'm allowing this to go forward to June 2nd because I've been advised that we have to, or else we're going to be subject to a big lawsuit. But if June 2nd comes and goes, and there's no development there, I'm open to new ideas for open space in the lake. And so the June 2nd deadline was the overarching factor going to the entire ability of this project to go forward. And that's, so during that time period, my client, Mr. Herbitz, was asking the city for public records about the Flagstone project. And even said in the requests, you know, would you please hurry this up because this June 2nd deadline is approaching and we're entitled to this information so that we can participate in the discussion taking place before the city commission, before the state cabinet. And although the city had been producing some records over time, they stopped cold as of May 5th, 2014. And that's in spite of requests on May 18th, June 3rd, on June 18th, specifically saying, what's going on here? Where are these records? July 3rd, another records request went in there, no response, other than, you know, we're processing your request, you know, an auto response. But no documents. And that was the time covering the city commission meeting on May 8th, the cabinet meeting on May 13th, and the June 2nd deadline. So on August 15th, Mr. Herbitz brought a lawsuit against the city of Miami, alleging that they had not produced public records for that entire period of time. At least May 5th to August 15th, that's a 14-week period. Now the Supreme Court of Florida has said that the requirement to produce these records is immediate. I mean, you know, maybe to physically assemble the records, you're allowed that amount of time. As Your Honor knows, the idea of a 14-week delay is unheard of and completely in violation of the law. Judge Trawick granted a hearing on August 20th in which the city admitted that it was physically in possession of all of these emails going all the way back to May 5th through July 17th. And Judge Trawick said, produce those. And we're going to have a hearing on September 5th to ascertain, you know, the status of your production. So we had a hearing on September 5th. The city filed an answer prior to that time. And in the answer, the city said, you know, we've given everything there is to give. And they filed an answer purporting to show that they had been cooperating throughout that entire time. And I documented in the reply that we filed, it's in the record, Your Honor, the numerous ways in which their reply was completely inaccurate. They simply hadn't complied during this period of time. So among the records that were finally produced after Judge Trawick ordered them to do so were documents going to the heart of the merits of what the city was doing with the developer. Like this email from the appraiser on May 5th to the city saying fair market rent was $1.8 million in 2002, it's $7.2 million in 2014. Well, if that had been made public, then it would have been clear that the city was violating the city charter by approving that lease. Instead it was withheld. And it wasn't produced until late August after we filed the suit and after Judge Trawick ordered it provided. And the complaint in this case is we have an Exhibit 1 goes specifically to these issues, okay? The withholding of documents, the withholding of documents about the meeting of the conditions precedent, the withholding of documents concerning the commencement date of construction. That's all directly in the complaint. And at the hearing on September 5th, we showed that among the records that had been withheld were records showing that the city had not met, that the developer had not met the June 2nd deadline to commence construction. Because they were looking around for the proper permit on May 30th. They were handing over physical records to the city, supposedly showing the conditions precedent were met, but when those were finally produced at the end of August, they showed that well into June, the insurance policies weren't in place, for example. But the overarching problem was that after June 2nd, the definition of commencement of construction under the agreement was that all plans and permits had to be issued and the actual act of physical construction had to begin. And everyone could see after June 2nd that the actual act of physical construction had not begun. So we pointed this out in front of Judge Trawick in September, and the city had taken the position, consistent with the developer, that they sent frogmen out there to photograph the seagrasses as part of the mitigation process, and that was really the beginning of construction. And the city bought that argument. But there was no commencement, there was no marina building permit that had been issued at the time, and the city said to the, to the public, through the press, and the developer said at the public hearing, no permit is required to commence construction. So this August 15th, 2014 permit to construct waterfront improvements for the dredging on the Flagstone project. They call it Island Gardens here, Your Honor, but it's the project. 1040 MacArthur Causeway. There are several different addresses. 850, 950, 1040 was the first time we actually saw this particular address. But this was evidently issued on August 15th, 2014. If that had been handed over in August of 2014, or in September of 2014 after Judge Trawick's order, that would have been in real time, given the public the ability to go back to the City Commission and say, they were telling you that they didn't need permits to commence construction, but now that they're actually out there starting, they've gotten a permit. So either you could commence construction without a permit, which was what they originally said to justify the fact that nothing was happening out there, or to do a seawall and dredging on that property, that's construction. That requires a permit. That permit was issued in August, but they were in clear violation of the contractual provision that all permits and plans had to be issued prior to, and the actual physical act of construction had to begin prior to June 2nd. So they concealed this permit for 6 months. And it was directly, now when we went back to Judge Trawick on September 5th, Your Honor, in addition to pointing out how our complaint addressed these very problems, and the city's answer did not address, and the city attorneys at the time gave inaccurate and conflicting information about what they were doing vis-a-vis permits, must modification applications. The central issue there was, and I've outlined it in the colloquy in the motion, that by the city not producing these documents in real time, a permit sometimes gives rise to the ability to challenge that permit in the court. And if you don't have it, you can't challenge it. So Judge Trawick said, I want all of these documents produced on an ongoing basis until all the city's witnesses or give a deposition here, and you can establish that you produced everything that the public records request requires. Now, the request that we, focused in on so that we could be sure that what they were producing was what was being asked, called for permits, permit applications, development orders, development applications, basically this. And it also included in the electronic records request, Flagstone, the name Flagstone, Island Gardens, those are all here. On the emails, they're all there. So how in the world those documents escape production for 6 months, you have to believe, based upon the overarching political and legal ramifications of the exposure of these in real time, the city withheld those intentions, Your Honor. That's the only conclusion that can possibly be drawn here. And that's why we've asked for an order holding the city in civil contempt if they do not produce within 10 days a sworn affidavit from a witness who has responsibility for this, explaining exactly what happened with these documents, why their production is currently complete, and how we can be sure that this is going to be complete in the future. Now, their motion today, their response today, takes other liberties, to be honest with you. It says, for example, that the plaintiff does not allege, nor can he in good faith, that we're aware of any other public records that the city is currently withholding. But that's not true, because if you look at the permit itself, Your Honor, it states, on the face of it, that it's being done in accordance with the plans, specifications, and application attached hereto. Well, the plan, specifications, and application is not attached to the document we received, and it's never been produced. Never. And the permit itself, Exhibit 3, says, the Department of Public Works shall be notified 48 hours prior to the time construction work is started. That document's never been produced. It's almost April of 2015. They started work out there sometime in the summer of 2014. So a lot of crucial information, Your Honor, has been withheld by the city. Not only in violation of Chapter 119, but in violation of this court's September 5th, 2014 order, which specifically was put in place so that the plaintiff could get in real time permit information, permit applications, permit decisions, development order applications, and development order decisions. That was what the entire discussion was about on September 5th, and respectfully, that's why I think it's obvious that Judge Trawick said, you've got to produce all this thing. The relief that we've requested includes not only having them respond within 10 days with the kind of, with an affidavit, also to produce paper versions of all of the records that would be responsive at the city's expense, and to allow my clients, me, the ability to go through those paper records with the city paying the expenses of that to ensure that they have fully complied with the public records request and with Judge Trawick's orders. That's the civil contempt order that we're suggesting to the court, as well as an ability to discern in the future how something like this is not going to happen again. And this is important for the following reason, Your Honor. Not only do the allegations of the complaint and the very, very serious 5-count complaint before Judge Porto turn on the ability for the public to have accurate information about what the city and the developer have been doing, which is now called into question because of this violation of the court order and violation of the public records law. The developer has continued to make modifications to the application. And whereas today 225,000 square feet of retail space in addition to the hotels has been approved, they're seeking another 140,000 square feet of commercial and retail space for this project. That's a pending application. And we only know about that because the city was forced to supply those applications to us because of Judge Trawick's order for continuing production. But if we can't be certain that we're getting in real time the city's responses to that application, and the city approves what would be a massive addition to the existing approved square footage of the commercial space on this project, and as Your Honor knows, there are serious questions about, the city simply has never done a current traffic study to measure the impact of the current project on traffic on MacArthur Causeway and Biscayne Boulevard, on Alton Road, on 5th, on Venetian Causeway, where Mr. Herberts lives and many of the plaintiffs in the other case lives, on West Avenue, on Bridge Road, on Fountain Avenue. In other words, the places that are already engorged with traffic, they've never done a current traffic study. And in connection with this new application for an additional 140,000 square feet, and this is not documented in this motion, Your Honor, but it is documented in my second status report. One of the documents we obtained was emails from the city staff coaching the developer on how to couch his application for expanded development so that it would not have to go through a public hearing process or a city commission vote. So it could be considered a minor modification. And that is, this is a series of emails from June of 2014, where the Flagstone's in-house lawyer wrote her president the following: City Planning has confirmed to us this morning that all supplemental drawings submitted by Nichols have resolved the issues which are pending before the city. However, for now, in order to keep all plans within a minor modification, City Planning has asked us that we remove the skylights from the permit submittal. Once we submit the new must modification package, which will take a few days, all revised drawings supplemented must be presented in one package with the full must revised application, and it has been determined minor, we can then go back with a revision submittal to add the skylights. So they're manipulating the process behind the scenes. We wouldn't have that if it wasn't for this public records lawsuit. This is the kind of, this is what I talk about, a pattern of illegality, a pattern of abuse of the public records law, a pattern of abuse of the public's right to participate. This withholding of the August 15th permit and related emails is all part of a pattern that, like I said, goes back to 2013 when they tried to get the doubling of the project approved in Tallahassee. It continued through the process in Tallahassee, and now the city has gone to extraordinary lengths, illegal lengths, to hide from the public the fact that this work required a permit. The permit was issued in August, and that the actual construction started in August, not before June 2nd, which throws the legality of the whole project, the helter-skelter going. So the civil contempt relief that we requested, we do believe, every one of these emails has been reviewed in advance of being produced. So Chapter 119.10 provides for civil and criminal penalties for violation by a public official of the public records law. We've asked that the court refer this matter to the state attorney, who can investigate either a civil or criminal violation. That's in the AG opinion that I submitted as part of our exhibits. And the criminal sanctions in the law have been upheld by the courts. This is a very serious matter. The public records law is part of the Florida Constitution. It's well defined in the Florida statutes. The idea that a citizen has to go spend his own money to hire a lawyer to force the city to produce public records mandated by law to be public in order to have information about what's going on in real time. And I have to add one other thing, Your Honor. One of the documents we got was a series of emails from May of 2014, because remember, on May 21st, I sent a public records request, and it has always been my practice to send it to the Office of Communications, which is in charge of public records for the city, as well as the attorneys, because we did have a previous public records case in front of Judge Cinnamon, which she refused to take continuing jurisdiction, and that's why we filed a lawsuit in front of Judge Trawick. But I've always copied the lawyers on these public records requests. And on May 2nd, we requested records. We are requesting the following documents to be produced as soon as possible, given the upcoming vote scheduled by the city resolution on May 8th, 2014. That was on May 2nd. In response to that one, the lawyer in charge wrote to the production office, please treat this as you would any records request. Ignore the fact that they asked for expedited treatment, given the fact that the city commission was supposed to come. And then on May 21st, when we made another follow-up request just to keep the ball rolling, the request specifically asked the city to produce these records as soon as possible because of the June 2nd deadline. And then, when no response came on May 23rd, a follow-up request saying, No one's responding to me. You've got a June 2nd deadline, would you please follow up with this? That email, then I got a response saying, hey, we got to go through all these, exemptions and the like. And I responded by saying, this has been pending for weeks. I mean, how long does it take? That email was sent by Mr. Zayon, the Chief of the Office of Communications, to Victoria Mendez, the City Attorney. Dear Madam City Attorney, I believe we should speak regarding this matter. My May 21st and May 23rd public records requests. Would you be so kind to grant me an audience? And if your Deputy City Attorney, Mr. Barnaby Min, could also join us to help illuminate us regarding this issue, it would be greatly appreciated. Regards. Victoria Mendez to her assistant, Marta, please set it up. And then more emails about setting up the meeting. Now, I did ask a couple of the witnesses the city produced about that meeting. None of the people who were on the string of emails were among the people the city produced for deposition. But that May 21st request started with records on May 5th, 2014. That was the next date for which we had not had records produced. And after this series of emails where the city attorney was asked to call a meeting regarding these requests, that's when the emails stopped. We got no more emails from the city, no more paper documents. We got almost no paper documents in 2014 anyway, but the emails stopped as of May 5th, 2014, again until we filed this lawsuit on August 5th. Coincidentally, on August 15th was the date we filed this lawsuit. And Judge Freywick said, produced the records that you're sitting on now. So, what's the relationship between this request for a meeting and the fact that those emails stopped? I don't know, Your Honor, but this is a law with criminal consequences that the city was clearly violating then. And now they've not only violated the statute by withholding that August 15th permit and those emails, they violated a court order in the process. So the remedies that we've requested in the motion are well called for, Your Honor. The cases I've cited show that you have the authority under civil contempt, under 119, under Rule 1.380, and under the court's inherent authority to enforce its own orders. It's all spelled out in the motion. I wouldn't take the court's time.
I just had a couple questions before I give them a chance to respond. Why, I think I know the answer to this question, but I want to make sure that you articulate it. Why is it that you're asking for paper copies? And you made it a point of saying paper as opposed to electronic or images or something like that.
That way, you can print it out, index it, have it right there physically in front of you, and go through it one by one and say, yes, it's here, yes, it's here. It's just a way to, maybe I'm too old-fashioned, but it's...
I'm just saying because there's obviously a greater expense in doing it by paper versus doing it electronically. And so I was trying to figure out.
We've done our best to keep up with the electronic production, and we have, and we're not complaining about it, and we pay. We pay what they ask us to pay when that happens, and we print it out and bear that expense. That's the way it is.
Typically, it's been produced on CDs or DVDs. Is that correct?
The emails are produced on CDs and DVDs, and then every now and then there's a batch of paper documents. Every now and then there's a batch of paper documents or a batch of PDFs that come on a CD. So,
I have a question. I think I know the answer to this one too, but have they been bait stamped or a unique identifier put on any of these? No.
That's what's so upsetting about this. I mean, how documents one of their witnesses testified that when they get a public records request, they don't really worry so much about the papers on their desk because they say the IT department is going to pick it up.
That was my next question, actually. What depots have you taken relative to what the city's process has been or is in, not in general, but in your case, who received it, what did they do with it, how did they go about?
We took 3 depositions. 2 of them, one of the assistant director of what was called public facilities, I think it's real estate, and that's Aldo Bustamante, and we asked him what the process is. And he said
you asked them what the process is for
what process that he
responding
followed.
to a public records request?
Yes. When you get a public records request, what do you do? And that's what I asked him, and we asked him what training they get.
But I guess
official responder for public records requests, as I understand it under the city's rules, is the Office of Communications, and they connect with the Office of Information Technology to execute these electronic.
Well, that's what I'm trying to figure out is have you been able to track from the time the request comes in, where does it go, who does what, who communicates with whom?
No, we haven't had a deposition on that, per se. I've tracked some of that because some of the responses we get show that trail, for example.
I mean, for example, an organization-wide email could be sent that said, "Dear all, we've received a public records request related to the Flagstone project. If you have any documents or data or information in any format related to this, please deliver them to such and such a person who's designated to be the gatherer or the collector of these documents." The way any organization would do a litigation hold or anything like that, that they would send out a communication in some format to anybody who may have relevant information.
They do something like that. I do believe they do something like that. We were told they do something like that by the two witnesses who...
So you were telling me the witnesses, Aldo Bustamante?
And Luciana Gonzalez. She is the assistant director of the Planning and Zoning Department. They were more talking about how they individually respond in this situation, but you might extrapolate it in terms of how the rest of the city operates. Honestly...
And the third witness was?
Alice Bravo. She is the deputy city manager, but at the time we deposed her, the city had taken the position that all the substantive areas had been covered and all the documents had been produced. We could clearly show that there was one problem with the traffic study, that there were no supporting documents had been produced. So our deposition of Ms. Bravo was limited to the issue of the traffic study, although we did, again, because we had sent her a public records request on the traffic study documents. So we did touch on the process that she goes through as well when she receives a public records request.
Were you able to figure out whether the city designates one human being as the responsible person to make sure that he or she has obtained from all the relevant departments and entities and employees of the city anything that's responsible?
I can't say I got to that point. I'm not saying they don't, but I didn't probe in that direction either, to be honest with you.
It would seem to me that that would help for accountability purposes if you said there's one person who is designated with reaching out to Mr. Bustamante and the other person in each department and making sure that those things are obtained.
I don't want to say more about that per se because my mind's fuzzy on what each of them said about that particular process. I was focusing more on, when they get a request, what they do, themselves.
And one of your requests for relief is to depose people, correct?
Absolutely, Your Honor, because remember, Mr. Bustamante said in his deposition, I have spoken with the departments who were involved with the Flagstone project, including Public Works, including Planning and Zoning, including some of the others, but Public Works is the one that issued this permit. And he said, and they have assured me that they produced everything. So I've got a sworn statement at that time saying they've talked to everybody and everything's been produced. When we were before this court back in January, where the city wanted to be relieved of Judge Trawick's order requiring them to produce things automatically, rather than me having to come in and request it, I couldn't say that he wasn't telling the truth. I had no basis to say that. I found a lot of problems with the process they followed, but I had no way to say that he wasn't telling the truth. Now we know that something is deadly wrong with what happened here. And to suggest that it's a process issue, I mean, we all know enough about electronic discovery to know that when the city's got a system that goes out after emails and has search terms, those things get picked up. How they got lost here is a serious breach of the law, serious breach of the court's order, and it suggests that anything else could be being withheld as well.
So part of your intention would be to go back to somebody like Mr. Bustamante, is that correct?
Absolutely.
And ask him what happened?
Absolutely.
Okay. And what else?
Well, the whole public, the meeting that the city attorney called in response to the fact that we were asking for records about, because of the upcoming June 2nd deadline, everybody involved in that meeting, should be deposed. Everybody in Public Works should be deposed who had a hand in this. I mean, they issued this permit. They must have gotten an email saying, do you have, the kind of email you're suggesting probably went out.
That's what, did Mr. Bustamante say he had gotten such an email?
what he said was that they get an email saying, if you have any records, produce them. But what Ms. Gonzalez said was that, and he said this too to some extent, even if they've got a piece of paper in front of them that might be responsive, they often just assume that that's going to get picked up by the IT search, which is done universally, which is done systemically.
Do you intend to depose the IT person?
I would, absolutely.
Okay.
I mean, that's part of what we have to do here. But again, this should be done at the city's expense, because they're the ones who swore under oath that every document had been produced, stated in two filings with this court that everything had been produced, and they're the ones breaking the law. Now we have to, they're the ones who are supposed to have a system in place to comply with the law immediately. And my clients have to spend their money to force the city to do what the law requires them to do in the first place. And that's not right. And they're suppressing, with the purpose of the public records law, it's not recreational. I mean, this is so the public can have vital information about what the government is doing and act on it in real time. And they've absolutely, eviscerated the purpose of the law. They've eviscerated the law.
Let me ask you something. Assuming, so I haven't given them a chance to respond yet, so assuming for purposes of my question that it's clear that a document should have been produced that wasn't produced, is it your contention that I have to, and I'll probably ask them the same question, that I have to make a finding in order to afford you some relief, that this was intentional, willful, that it was an act of concealment?
No, Your Honor, we are not doing that at all.
Okay.
That's why this is civil contempt. It's for the purpose of fixing the problem, as your authority would cover. But the imposition of a fine if they don't do it, and the payment of fees required to bring them up to compliance should certainly be their responsibility and not my clients. And there's ample authority under, like I said, contempt, 1.380, 119, or inherent authority to force the city to pay all those costs.
And then I think my last, with respect to your request of a referral to the state attorney's office, have you or somebody that you represent gone and made a complaint to the state attorney's office?
At this point, Your Honor, no.
Is there anything that you feel precludes Mr. Herbitz or anybody else who's interested in going to the state attorney's office and saying, I want to make a complaint?
No, Your Honor. I mean, there's the 119 violation, which I think is very clear. There's the aspect of it that it's a violation of the court order. So, not that it's like an exhaustion issue, but, we felt it was appropriate to include it in the relief that we're asking this court for, because it is this court order that was violated. That's the tipping point, so to speak. And that's why, that's why we are where we are now.
Okay. All right. Thank you very
so
much.
Good afternoon. So I'll pick up on the last series of questions that Your Honor was asking, particularly with regard to whether the court needs to make a finding as to willfulness. The fact that they're going under a civil contempt type theory, violation of a court order, there would have to be a finding of willfulness. There is no evidence in the record whatsoever that there was any willful attempt or intent to conceal or withhold any type of documents. The record is clear that the city has been inundated with numerous and continuous public records requests from the plaintiff going back to at least June of 2013. In that nearly 2-year period, the city has responded to every single request and has produced tens, I would venture to say tens of thousands of records to the plaintiff. And so for the plaintiff to say that there is one document that allegedly was just recently produced, to say that that indicates willfulness or a criminal intent or anything like that, which would indicate that the city or any of its employees was willfully violating a court order, is outrageous. It really is, considering the lengths that the city, the amount of time that the city has expended in responding to the request beyond the normal duties that the employees engage in. it's not accurate what it is that he's representing to the court. I provided a response earlier this morning by e-courtesy. I apologize it wasn't done earlier, or it wasn't as detailed as it should be. I was out of the country for the last week or so, and Mr. Dubin filed this motion and set it for today while I was out. I just didn't have time to prepare for it. Considering the type of sanctions that he is requesting, I can't say that I'm thoroughly prepared to address each and every one of those right now. What I can say is that Mr. Dubin has a motion for attorney's fees that is currently pending before the court, in which 99% of the things that he was talking about are covered in that motion. I would respectfully request, in fairness to the city, in order to be able to thoroughly brief and present an argument to the court, that everything be handled at the same time. The same issues that he brought up are the same issues that the court can deal with at once rather than in a piecemeal fashion. I just want to address, just from hearing his argument, that he talks about a pattern, because I think that ultimately, when the court decides what to do as far as resolution of this case, it talks about a pattern of illegality. Well, there is a pattern in this case, and the pattern is numerous public records requests to the city and ample responsive production of records to the plaintiff. That is documented in this case. The plaintiff has filed 3 lawsuits against the city. In each of those lawsuits, he has argued that the city has been doing illegal things, illegally withholding, intentionally concealing documents, and has presented this type of argument to the court. No court has agreed with him. As a result, he has 2 appeals that are currently pending in the 3rd District. And as I said, they're still pending. We'll see what happens with that. But there is no order out there that has found that the city has engaged in any type of unlawful delay or withholding of any sort. So that's just Mr. Dubin's argument, because obviously he and his client, they don't like this project. They don't like the city, they don't like what the city has done. But just because they don't like it doesn't mean that what the city is doing is illegal. The city has done everything to comply with each and every single one of his requests, which comes on probably on at least a monthly basis, in order to comply with each and every one. And we get requests not only from him, but from the media. So to say that the city would intentionally conceal these type of records, knowing it's going to come to light, there's no motivation, there's no reason for doing that whatsoever. The city has and will continue to produce records, and the best indicator of whether or not the court or the plaintiff can ensure that the city will continue is based on its past history of producing thousands of records, and Mr. Dubin, he can't dispute that that is the case. We promptly acknowledge each and every one of his requests and produce it. We make it convenient for him to pick it up. We make it available at a convenient time. We offer to deliver it to him. Most times he elects to bring a courier to our office, and we provide it to him. Other than that, as I mentioned, I don't, at this moment right now, I can't. I would prefer to, and I think it would benefit the court, to have a detailed written response, not only to this particular document, but to the other documents that are the subject of Mr. Dubin's motion for attorney's fees. And I think it would be an appropriate, in fairness to the city, as well as an appropriate use of judicial resources to allow us to brief that issue and set that for a special set hearing in which we can hear everything all at once. Because not only will that resolve that issue, but depending on the court's ruling, that will resolve the case completely.
The court's ruling on the motion for attorney's fees.
The motion for, that's really the only thing that's left to do in this case. In a public records case, the issue is get the records, we've given the records. Even this document that they say they didn't have before, they have it now. And by the way, section 119.11, which provides the mechanism for an immediate hearing, which we're on here today, that's not for sanctions. That is in order to get the requester records. So what would have happened is, if they believed that if there was a record that, say for example, we were claiming was exempt, or privilege and that we didn't want to produce it, we would have a hearing, we might produce it in camera, or the court would say, okay, produce this record at such and such time. They already had it. There was no reason to bring this on an emergency basis. This can be set in the normal course in a special setting in order for us to address not only attorney's fees, but whatever other relief that he believes is appropriate.
Have you had an opportunity to go to Mr. Bakhtiar, for example, and say, what happened?
That is on my list of things.
Okay. Can you speak to, are you able to speak to the issue that I was asking Mr. Devin about what the city's process is for making sure? One of the things when I go back to Mr. Devin is, my recollection, and I'll ask him and I'll ask him as well. In this last case was last before me, there was a disagreement about whether there was an ongoing obligation as even new documents were created to produce them. And I think the conclusion that I had reached was that if the plaintiff wanted to seek a permanent injunction, the nature of a permanent injunction to require the city on an ongoing basis to produce documents, the plaintiff was free to do that. And I don't, my recollection is that that was not going to be pursued. But I'll ask Mr. Devin also, but what was your recollection?
My recollection of that wasn't the proper hearing for that, or the motion at the time. That's not what that was for.
Okay.
And also, an injunction would require that there's a documented history and that, a likelihood that the city's not going to produce based on failing to produce, and it would have to be something egregious. I mean, I don't think that a document, which even if it wasn't produced at a certain time, the fact that it was, it shows that the city is continuing to produce, and it will continue to do so.
But, I mean, I think to a point, to the extent it's, this case, this matter is obviously one of some public interest. And so to the extent it's practicable, that they make the point that contemporaneous, or as close as possible to contemporaneous, is important, so that when they go to the city commission meetings, wherever there's an opportunity for public input, they have all the as much information as they can have to be able to intelligently address their elected representatives as to these issues.
And I understand that. The issue is, though, with public records, there's no right to a standing request, and that's essentially what they're asking for. Now, to the extent that they file, and they have been consistent in filing a public records request, we then produce it. And just because they make a request or they believe that a record exists, there may not be. And to get to your questions about what the process is in place, essentially it comes in to the city and it gets sent out to the various, Mr. Dunham is pretty clear, at least in the last request that he's made, it goes to the mayor, the individual commissioners, and the various departments in the city. So it gets sent out to that, and then
You're saying that a citywide email goes out?
to the various departments, and then there should be, or there is an individual in each department that is kind of like, I guess the closest you can say is a custodian of records who gets it and then follows up within the department. Do you have any responsive records? Yes. Okay, we'll provide it to
But I
our
guess my
office.
question is it, I don't know if there's an email system that says all employees, for example, and then it goes to everybody who may have a file on their desk, from somebody who issues permits or whatever it is. Please check your desk and your surrounding area and your desktop for any information you may have related to the Flagstone development.
As far as that email, I can look into that, but I'm pretty sure that it is an individual within that department who then sends it to the employees. So it kind of covers it. Instead of there being one, there may be multiple, but I believe that would be the way that it would be done.
Okay. And, because I'm going to ask Mr. Dubin the same question. Are there any cases that you would point me to, or other authorities, with respect to the requirement that I find that this was willful or intentional, as opposed to whether it was negligent or willful or intentional, but it wasn't produced? Whether it was a mistake, whether it was an accident, whether it was an intentional scheme to hide something. Are there cases that say that I have to make such a finding before I afford him some relief for what appears to be the failure to produce something that should have been produced.
Yes, for the theory that they're going on, yes, I do believe that there is.
Do you have a case
I
that says that?
I don't have it right now. I wish I had more time.
Okay.
I would have thoroughly researched that, and that would be part of my detailed response that I could put it in and in order to advise you on.
Okay. What's your response to their request to depose people about this issue? And I would say about the thoroughness of the search that has been done, leaving aside monetary sanctions and, you know, some of the other relief that they're requesting, but their response to depose people.
I don't believe that it's warranted. We sat through Ms. Gonzalez, Mr. Bustamante, and Ms. Bravo. I think each averaged about 4 hours with the deposition time, in which he was able to ask any question that he wanted. Mr. Bustamante and Ms. Gonzalez, if my memory serves me correct, before the deposition, they indicated that they contacted the various offices, and so they, because they were designated as the people with the most knowledge, and so they essentially were being deposed as custodians of records. And the custodian of record, as your Honor is aware, may not have personal knowledge about everything, but goes to the various departments and speaks with the individuals and says, do you have anything responsive to this request? And then they go from there and they report their information. So I believe that they did that investigation in good faith. So to redepose them on that, it's not going to change anything. The information that they got at the time of their deposition, that's not going to change. And it also goes back to as far as whether or not to have additional depositions. They haven't made a showing that there are any records that are outstanding. We have produced not only the thousands of records that were under his prior request, but under Judge Treywood's order, as well as he continues to make current public records requests. So we are producing on a continuous basis.
Who would have been the person who was in charge of making sure that Mr. Bakhtiar produced documents?
As far as his supervisor, or
Yeah, the person that you said who would be designated to send out an email to the department and make sure that they were collected. Was it one of the 3 people that he already deposed?
no, it wouldn't. It wouldn't necessarily be them at the time. It was the Office of Communications, and they have people in that department who receive it, and then they would have forwarded out the request.
Do you know how these things, I think that it says were produced March 3rd. How did these come about? How did this?
I believe that came about because as of earlier this year, I'm not sure what the time period was, but there's an individual in our office who, I guess, kind of, I'm not going to say he's the custodian of records, but he's kind of like the point person.
In our office being the city
The
attorney's
city
office.
attorney's office. And I'm not sure what they did. I have to follow up with them to see who they sent it to, and I just know that there was an email that was sent out, and whatever records were given in response, that's what it was.
Anything else that you want to tell me?
I think, obviously, I would have liked more of an opportunity to write this all
Well,
out.
and I'm going to ask Mr. Devon about that. I mean, I'm going to talk to him about that. But if there's anything else. Sure.
I guess the last thing I just want to make clear is that Mr. Duggan referred to it a few times, but he does have 2 pending cases right now. One in front of Your Honor, which is a public records case, and the other in front of Judge Gordo. And he's conflating the issues and making arguments and then talking about things that, you know, he does it in front of Judge Gordo, and now he's doing it in front of Your Honor, which is kind of it's confusing.
Well, I try as best I can with these matters to really focus in on what the issue is that's presented to me. And I guess I'll ask you the question which I haven't asked, which is, do you disagree that these August 15, 2014 materials should have been produced?
They're public records. Yes.
They should have been
All public
produced
records,
already.
Public records should be produced.
Okay. And so if it didn't happen, it should have happened, but it didn't happen, whether it was intentional or not intentional, it should have happened.
I can say this as not doing it and investigated it as a public record should be produced. Whether it hadn't been produced yet, I can't say, but it should be produced.
You mean you can't say whether it had
Or
already
what the
been
reason, well, if it hadn't been produced already, the reason behind it, I couldn't say, but as a public record, yes.
Okay. All right, thank you very much. So with respect to whether or not there's a willfulness requirement, can you address that?
Yes, Your Honor. Here's the way I think it would work. We're asking for civil contempt, we did not ask for criminal contempt. That would require a trial and a, finding of. I believe that what would happen here is in order to show cause why the city should not be held in contempt if it does not comply with the relief that would explain what happened. So, production of the records, the conduct of the depositions, the affidavit. In other words, if they don't do the things that the court would deem necessary to address this problem, because you would have put that down in writing, here's what you have to do by this date. If they don't do it, then they would be in contempt, and that would be willful because they would have had the opportunity to have done so. But there's no requirement that you find them to have acted willfully in order to get the court to enter that order. Because in other words, in the Supreme Court said in Parisi versus Broward County, because civil contempt sanctions are viewed as non-punitive and avoidable, fewer procedural protections for such sanctions have been required. Thus, civil contempt may be imposed in an ordinary civil proceeding upon notice and an opportunity to be heard. Neither a jury trial nor proof beyond a reasonable doubt is required. While civil contempt sanctions do not require the same procedural and constitutional protections as criminal contempt, the key safeguard in civil contempt proceedings is a finding by the trial court that the contempt nor has the ability to purge the contempt. So it's making it, and as I read that, I'm looking at the other cases that we cited, and that's what happened. The court said, look, something went wrong here, here's what you got to do to fix it. And they were given one or two chances to do it, and if they fixed it, then, it was within the court's authority to award the fees and the like. Sometimes they didn't fix it, or they fixed it too late, because they continued to violate what they were called upon to do, in which case the court said, you didn't do what I told you to do, I'm going to fine you as well. But there was always a clear requirement as to what had to be done, what was violated before that contempt. So they wouldn't be in contempt unless they failed to do what the court ordered them to do in order to rectify the problem.
So part of your request for relief, although it's not in the ones that I flagged, is in order to show cause.
Correct. That's the essence of the first remedial action that I was requesting.
Okay. Well, I think actually the order to show cause procedure would give Mr. Andrews, in a sense, the time that he's seeking to investigate this, because that would be where he would show the cause why the city should not be held in contempt of court.
I think that's appropriate, Your Honor. I think that's a logical conclusion. And going back to Your Honor's statement before, you do remember correctly what happened when we came to you at that time, which was you said this complaint seeks injunctive relief, and if they see a need for it, in the case we cited was Daniels v. Bryson in the 3rd District, where because there was a history of violating the court orders, the court said it would be appropriate to have an injunction under these conditions where there's a history of violations and a likelihood of future violations. So that is a remedy that would be available. That's what happened at the time. Subsequent to that, we didn't have a need for that until now. Because we relieved them of the judge of the September 5th order, and we've gone through a couple of requests, and here we are.
Is what you're asking me to issue the order to show cause before I take any further action that you've asked for?
Yes. But I would respectfully, yes, Your Honor, that's what we're asking.
And I think it certainly is appropriate for me to issue the order to show cause. Andrews an opportunity to answer and investigate the answers to the questions that I was asking, such as, and I guess I'm saying this more for the city's benefit, speaking to Mr. Bakhtiar and finding out what, who knew what when, and when did you find this out? How did this request come to light? What did you do with the paper? Who did you send it to? I mean, unfortunately, fortunately, the devil's in the details of these things, and that uncovering those facts or that evidence then will give us a better idea of whether anything was willful or not willful, intentional or not intentional, or that kind of thing. But clearly, I think he's conceded these documents should have been produced and weren't. And so the question is, why did that happen? And what's the process for that?
And where the depositions fit in, Your Honor, I mean, obviously there were statements made, under oath and to the court about the completeness of the process. So,
Yeah, and I mean, I'm inclined to allow those depositions to take place, but I guess I'll issue the order to show cause first. And of course, reserving on who should bear the cost of these questions until they've had an opportunity to fully respond and explain why this wasn't produced and what the process is and all that. And then, depending on what the answer is, I guess we can take it from there. And I'll give you as quick a time as I possibly can. When everybody's available, early in the morning, late at night, whatever it is. But I guess my other comment would be that not just redeposing the people who've already been deposed, but I think it would benefit all of us to know exactly what the city's process has been in this case. I mean, even if, typically in electronic discovery, as you probably already know, you have to sometimes hire, again, leaving aside later on whose expense it's going to be. You hire your own IT person to advise you, and you do discovery. What type of computer system do you have? What keywords did you use to search? All of these things to figure out what the process was for this. So, I will issue the order to show cause, as I've stated, why the city should not be held in contempt of court, and I'll reserve on all the other requests for relief that are set forth in here.
thank you.
Pending that response.
Thank you.
All right. Thank you all very much for being here.
All right, please.